Governor Hyacinth Alia of Benue State has suspended the state's Attorney General and Commissioner for Justice Fidelis Mnyim for his involvement in a legal challenge against the establishment of the Economic and Financial Crimes Commission, EFCC, and the Independent Corrupt Practices and Other Related Offences Commission, ICPC. The suspension comes amid a Supreme Court case where 19 states are contesting the constitutionality of the laws establishing the EFCC. The court reserved judgment on the matter this week, and new dates are expected to be communicated to the parties.
The states now, excluding Benue, argue that EFCC's Establishment Act of 2004 was not properly enacted, according to Section 12 of the Nigerian Constitution, which requires specific legislative steps for incorporating international conventions, into domestic law. Joining us now is legal practitioner Ibukun Fasomi to, of course, expand a little bit more about this. Good morning. Thanks for joining us.
Good morning. Good morning, viewers at home.
All right.
A pleasure to be here.
Great to have you. I think we probably would start with, your general take on the case against the EFCC by these states. Many have argued that, it's been engineered by the Kogi State, former Kogi State Governor Yaya Bello, and others, similar to him, who are trying to reduce the effect that EFCC has on these state governors when they leave office. But what's your general take on the case against the EFCC?
Well, for me, I think we should understand that as lawyers, when something is found to be illegal or not in full compliance with the law, by virtue of our professional ethics and oath, we hold it a duty to challenge it. And most times, when you see people who are the chief law officers of a state, who are called attorney generals, it is within their duties to ensure that law is upheld and the rule of law is seen to be done in all circumstances. So for those who have approached the court for interpretation of some sections of the Constitution in line with the EFCC Establishment Act, they are still within their right to do what they have done. That said, I would also say that the truth of the matter is that if the Supreme Court, at some point, in the case of OBK, had concluded and reached the conclusion that the EFCC Establishment Act was a product of a convention, which obviously was not in line with Section 12 of 3, I believe that the Supreme Court will, one way or the other, have to look at it again and give a decision. Thankfully enough, that matter has been argued and reserved for judgment. So I won't comment further in that regard. But coming to the issue of general belief and insinuations as it relates to the governor of Kogi State or former governor of Kogi State, particularly that the Attorney General of Kogi State instituted the action while others had joined, we cannot also rule out the fact that they have taken a matter before the Supreme Court which they perceive to be a matter of law that the court must rule and give a judicial imprimatur to. So the issue of sentiment and law, they are not the same and they will never be together. Anybody can insinuate. The question is, has any issue of law been submitted to the Supreme Court? I said the answer is yes. And for that reason, we must try to bifurcate sentiment from legality. So the issue that is before the Supreme Court is on the legality or otherwise of EFCC Establishment Act, particularly in line with Section 12 of 3, and also the Attorney General has canvassed Section 15 of 5. So all of these have been submitted for determination, and I can assure you that the Supreme Court will decide it one way or the other.
Let's also talk about the legality or otherwise. I mean, is there an issue to be spotted here with the fact that the governor suspended the Attorney General? Does he have such powers? Because there are some people who have probably criticized, this act. So does the governor have the power to criticize the Attorney General, or is that an issue that has to be looked into as well?
The hard departure point to answer that question is that we must understand that all commissioners and government appointees of the governor are in that position at the pleasure of the governor. Is in the Constitution. They are appointed at the pleasure of the governor. And that explains why some of us over time have canvassed that the office of the Attorney General and Commissioner for Justice should be bifurcated. Ordinarily, had it been the office is bifurcated, you know that there is a level of or measure of control that a governor can exercise over an Attorney General. But in this circumstance, the office of the Attorney General and Commissioner for Justice are together. And by virtue of that being together, there is a level of clearance and compliance that an attorney general must exercise before he takes an action on behalf of the governor. It needs not to be said that the governor is the chief law chief law officer of the state. I mean, is the chief of the state, and of course, whatever is happening in the state, the consent and the approval of the governor must be sought and obtained. So the governor has a right to suspend his appointee because he was appointed at the pleasure of the governor.
Okay, I mean, what do you expect to happen next? You know, and now that of course, Benue State has taken this particular step, the federal government, of course, is asking the Supreme Court to dismiss the suit. What do you expect to play out next?
Well, it is going to be a difficult one for the Supreme Court, having regard to the fact that several decisions of that court has been made, particularly on the legality of the EFCC Establishment Act. Also, we must note that the issues submitted, they are constitutional issues. You don't need to go to law school to read section 12 of 3, and you don't need to go to law school to read section 15 of 5. All these issues together, put together with the arguments of canvas, there are things that it's actually predictable. But we must know that Supreme Court is infallible. Supreme Court is not infallible, not because it's final, but it is final because it is infallible. Whatever the Supreme Court comes up with becomes a policy decision of the court, which nobody can appeal except to God. And in that regard, we must await. We cannot predict the Supreme Court. We cannot also begin to think that this is how it will go or not. But the question is that over time, Supreme Court has been seen as a policy court who will consider a lot of factors before coming to a decision. Like I said, the Supreme Court made a finding in the case of Joseph Nwobike and Federal Government of Nigeria. So that particular decision is still there, and it was cited. Then also the issue of whether states can say that, the states must do everything to abolish corrupt practices. Does that in any way give a hanger toward the EFCC to act on laws of state that was not passed by state? Section 12 of 3 talks about how conventions can be domesticated, and that proceeding was clearly not followed. It is there. Nobody has contested whether it was followed or not. Nobody is trying to justify corruption. Nobody is trying to justify that EFCC is not doing a fantastic job. The point we are trying to make is that, can we legally say that EFCC Establishment Act was well-founded? So the answer will be done and given by the Supreme Court in a number of days from now.
All right, Ibukun Fasomi, thank you so much for joining us this morning. We hope to have you again when we have a headway as to how this case proceeds. Thank you for your time.
My pleasure.